afternoon, everybody. My name is Giacomo Delledonne. I'm assistant professor of constitutional law at Scuola Sant'Anna in Pisa. I'm one of the editors of the Sant'Anna Legal Studies paper archive, together with my colleagues and friends, Giuseppe Martinico and Filippo Fontanelli. Today, I'm very happy to introduce a webinar whose title is the French political system in crisis, constitutional and democratic challenges of the retirement reform of 2023, featuring Eleonora Bottini as speaker. Today, we will discuss the constitutional implications of the ongoing institutional and political crisis in France. The recent events in France have been closely observed and discussed in depth in Italy, in Europe, and elsewhere. The approval of the retirement reform served as a catalyst, perhaps, to unveil, to reveal the existence of some major flaws of the constitutional model, but to understand the reasons for this crisis, you may have to look back and adopt a longer-term perspective. Radical transformations in the French political system have occurred since 2017 and have not settled yet. Moreover, the results of the presidential and legislative elections in 2022 have given rise to semi-permanent political conflicts. An important aspect in this crisis is that almost all the state branches have been concerned: the president and the executive in general, the legislature, and the Conseil Constitutionnel, of course. There have been attempts to activate direct democracy procedures to abrogate the freshly approved reform. Also, for this reason, a recurring idea is that the crisis triggered by the approval of the retirement reform affects the constitutional order of the Fifth Republic as such, or at the very least, is the most serious institutional crisis since the Algerian War. As I have already said, the crisis has been closely observed from outside. The Venice Commission has been requested to adopt opinions on result to the well-known Article 49.3 of the Constitution of 1958. This is not unprecedented, not at all, for a country in Western Europe, but it shows that the latest development in France have raised substantial concerns. And this is why a discussion of these events fits in very well with the contents, the concept of the Jean Monnet module, enacting European values in context, of which this webinar is part. As an Italian scholar, I have to add, the French events are of the greatest interest, having in mind the ongoing discussion about constitutional reform in Italy. A well-known aspect of the French model is, of course, the strong institutional position of the President of the Republic. Far less known, by contrast, is the French variant of parlementarisme rationalisé, a peculiar way of regulating the relationship between the executive and the legislature. Our speaker today is Eleonora Bottini, professor of public law at Université de Caen, Normandie. Eleonora got her PhD from the Université Paris-Nanterre. She worked at the research department of the Italian Constitutional Court in Rome, after which she served as maître de conférence at Université Paris Panthéon-Sorbonne until she was appointed to the University of Caen. Her research interests lie at the crossroads of comparative constitutional law and legal theory. At the end of March, a short comment by Eleonora was published in the Verfassungsblog. The title was "Constitutional Perhaps, Democratic Not So Much," on the French government's maneuver to pass the law on retirement. It's a thought-provoking reading, and I suggest that you take a look at this if you are interested in this issue. So we will have some time for debate, and I'm very happy to give you the floor, Eleonora. Thank you for being here.
Thank you so much, Giacomo, for this very flattering and nice presentation. Thank you, really. And thank you to you and all the organizers at Sant'Anna for inviting me to speak about this issue, which is, of course, the main topic of conversation in France right now and has been for the last few months. And I'm sure it will be one of the main topic of conversation for the years to come. So as you suggested, I will talk based at first on my piece on Verfassungs's blog, and then, of course, adding updates because some important things have happened since I wrote that piece, mainly the decisions of the Constitutional Council, which were still awaiting when I wrote that, and another development that is actually ongoing right now. So we will not have all the answers because some things are still going to happen next week. I will mention that. So we are really in the midst of the debate, even though some things have already been decided. And I think I will start with that as an introduction. What is already ongoing and what is still to come. So the reform of the retirement that we're discussing was announced already by Emmanuel Macron during his first term in 2019. But then it was abandoned due to the COVID-19 crisis, which arrived in the middle of protests, significant protests about this reform. The proposal was restored again in 2022 after the presidential and legislative elections, given also that this one is Macron's last term due to the 2 terms limit rule that was introduced in the constitution in 2008. It is very important to underline right at the beginning that contrary to the last term and contrary to the usual situation of the French Fifth Republic, the president's party only has a relative majority and not an absolute one in the National Assembly in the lower chambers. So the majority, the presidential majority, has to count on a coalition to govern, but not everyone in the coalition was in favor of this particular reform. And this is a very peculiar situation for France, which usually does not rely on coalition governments. So this we have to keep in mind to understand what happened. So the main innovation, as everyone probably knows, of this complex reform of retirement is to raise the minimum age of retirement from 62 to 64 years old for what's called the general regime, which is the most part of the active population. This raise is, this change in the minimum age of retirement is the one that raised most criticism and protests, but I will not enter into the merit of the reform as I'm not an expert of the budget of Social Security, which is at the heart of the debate on the reform. So some say it is necessary to compensate for the deficit of French Social Security. Others would say it is not necessary and will not help that much. I do not have an informed opinion on this question, not informed enough at least. And I would like to concentrate on the challenges that this reform brought about for French democracy, which is slightly separate issue. So those challenges are twofold. One is the extreme rationalization of the legislative process in the French Constitution, as well as the uses of the mechanisms of rationalization by this particular presidential majority. The other challenge pertains to the absence of a strong constitutional court in France and to the limits of the action of the French Constitutional Council. What I think and what I would like to put forward is that those two challenges are related, and the fact that they coexist is what makes the hypothesis of a crisis of French democracy particularly, let's say, significant, or at least probable in my view. And that's a conversation that we can have also during the debate. So the retirement reform has now been adopted. It is currently being applied, as the application decrees, the executive orders for the application of the reform have been published in yesterday's official journal. So in a sense, this is done. The reform is done, and it is ongoing. It is set to be applied starting September 1st, 2023. And so one could think that there's not much to be done, but in fact, there is, and the ongoing conversation is still open about the possibility of a vote about a new law that I will discuss a bit later, that would abolish or abrogate the reform that has been approved. So the raise of the retirement age from 62 to 64 years old. So I would like to start from the beginning, let's say, of the first challenge, which is the accumulation of, or the uses of constitutional mechanisms to rationalize parliament that have been combined since the beginning of this legislative story, let's say. And this story starts on the morning of Thursday, March 16th, when French President Emmanuel Macron met with his Prime Minister, Elisabeth Borne, and the other members of the cabinet in an emergency government meeting about the ongoing reform of retirement. Because the reform had been met with fierce opposition by the unions, by the political opposition in parliament especially, and apparently by a large part of the population, if we follow the different public opinion polls that have been done throughout this discussion. The proposed bill had been the object of a procedure of conciliation by what's called a joint parliamentary committee, a committee composed of 7 senators and seven deputies that agreed on a common version of the bill. But then that common version has to be voted by both chambers of parliament. The Senate had adopted the text with a comfortable majority. There was not much of a surprise, but the National Assembly was more risky for the governmental and presidential majority. So only a few votes appeared to be in favor of the text, and the risk of a rebuke was an important one. So the president and the prime minister together decided to activate this famous Article 49, paragraph 3 that you mentioned, Giacomo, in the introduction. Article 49, paragraph 3 of the French Constitution allows the government to engage its responsibility in front of the lower chamber of parliament, the National Assembly, on the vote of a bill. So when the prime minister requests this engagement of responsibility, all debates are interrupted in the National Assembly, and after 24 hours, the opposition has the possibility to adopt a motion of no confidence. In that case, the government would be forced to resign, and of course, the bill would be abandoned as a consequence. And the other, let's say, the other possibility, and the one that's much more frequent in France, is that the bill is considered as adopted because there is no motion of the no confidence that obtains the absolute majority. And so the bill is adopted without a vote by the National Assembly, and the bill is considered as passed as such, which means in the version of the compromise text of the joint committee. So this is what happened. Elisabeth Borne, Prime Minister, activated Article 49, paragraph 3. And of course, all the opposition parties have started to organize their no confidence motions. And there was one in particular, was filed by a member of the National Assembly who is part of a centrist group of the opposition. And that has been the most popular one because it was supported by 278 members of the National Assembly, only 9 votes short of what was needed of an absolute majority of the 577 members of the National Assembly. So the vote was very close. And then there's another element that is important to note, which is that the Republicans, so the center-right, that is supposed to be in coalition with the government, also had 19 out of 61 deputies voting in favor of this motion of no confidence. So that means that the presidential majority has crumbled in a certain sense, and it's much more, let's say, in dire straits than at the beginning of this procedure. So this was Article 49, Paragraph 3, which has a long history that I mentioned in the article. I will not focus on that history now, except for one aspect, which I think is particularly important for our discussion, which is that this article has always, or almost always, worked in favor of the governmental majority, in favor of government. So it has been used 100 times by now, since 1958, and every single time the motions of no confidence have failed to be adopted. In French history, as it is well known, there has been only one motion of the confidence that has, in fact, passed and has conducted to a government resigning, and it was not as a consequence of Article 49, Paragraph 3. It was a separate motion of no confidence in 1962. Since then, there has been no motion of no confidence that was successful, and none in this particular case of Article 49, Paragraph 3. So that, I think, is an important aspect to retain. The other element that I think it's important to mention for our case here is that Article 49, Paragraph 3 has been changed in 2008 by a constitutional reform that wanted to avoid the abuses by governments of this particular article. And in order to reduce the number of occasions that Article 49, Paragraph 3 can be activated, the constitutional reform of 2008 states that only financial laws, so that means the state budget and the social security budget, can be passed with this particular article, together with one other bill, no matter which one, chosen by the government. And that is the case every year, every parliamentary session. So let's say a maximum of 3 bills, financial, and one other bill at the choice of the executive. Of course, for each of those 3 possibilities, 3 occasions that the government can activate Article 49, Paragraph 3, the article can be used multiple times as long as it is for the same bill. And so that explains that the Prime Minister, Elisabeth Borne, in the fall, in November, December of last year, used the Article 49, Paragraph 3, 10 times to pass the state budget. And this is because it was always on the same bill, the financial law, the Loi de Finances. So this more recent use actually relies on another article of the Constitution. That's a bit of a complexity of this particular case, because the retirement reform in question was actually inserted in a bill meant to rectify the 2022 Social Security budget. That is not a common choice. It was not an inevitable choice. It is a choice that the government has done specifically, or at least that's my interpretation, to be able to use Article 49, paragraph 3 without spending the last option of using this article for this year, because it is included, let's say, in the financial laws option. And so not only this choice of the government has a consequence on the use of Article 49, paragraph 3, but is also the result that all this parliamentary debate about the retirement reform falls into the scope of another article of the Constitution that has been much discussed in France in the last few months, which is Article 47.1. Article 47.1 limits the number of days for the overall discussion of a Social Security budget bill. The overall discussion, both of the lower and the higher chamber in Parliament, cannot exceed 50 days. Otherwise, the government will have the right to pass the same measures through executive orders, bypassing Parliament altogether. And of course, those strict timeframes do not exist only for Social Security budgets, but also for the state budget. And they're fairly typical of financial laws in general, because they are meant to ensure that the state budget and the budget of Social Security are approved in time at the end of the year in order to be operational for the beginning of the fiscal year. But this, of course, was not the case for this retirement reform, as it is a rectification of the 2022 Social Security budget. And also, this retirement reform had been introduced in January. So there were virtually no risks of not adopting the bill before December 31st, 2023. That is why the use of this article 47.1 is very controversial and potentially, at least that was the criticism, potentially unconstitutional, or at least a stretch of the procedure. The combination of Article 47.1 and Article 49, paragraph 3 is certainly unprecedented. And that is why there is such a reflection on the constitutionality of this entire operation. The combination of many different parliamentary tools does not end with the adoption of the reform. And now I'm going back to this last attempt of blocking the reform that is right now ongoing and that I mentioned at the beginning. So a last attempt of blocking the retirement reform was initiated by the opposition a few months ago in April, using or planning to use the so-called niche parlementaire. So that would be a parliamentary reserved space. What's this reserved space? It is a day per month that is reserved for the opposition groups to introduce and to vote new legislation at their initiative. And of course, the different opposition groups have to distribute those reserved days amongst themselves. And so that means that pretty much every opposition groups have only one of those reserved days per year, every parliamentary session. And the centrist group that I mentioned before, the one that had introduced the motion of no confidence that was most successful, even though it didn't work in the end. This group is called in French LIOT, Liberté, Indépendant, Outre-mer et Territoire. So that's a parliamentary group that is in the opposition. And this particular group will have this reserved day, this niche parlementaire, on June 8th. So very soon, this week. And they have decided to use this particular day in order to vote on a parliamentary bill that they introduced in April that contains, amongst other things, the abrogation of the modification of the retirement age from 62 to 64. So basically, their initiative says we want to eliminate this particular part of the retirement reform. So they have introduced this initiative. The initiative since April has been approved by the Bureau of the National Assembly and by the Finance Commission at the National Assembly. But last week, on May 31st, the Social Affairs Commission, which is another of the permanent commissions of the National Assembly that has to examine the text due to its content, well, this Social Affairs Commission has rejected Article 1 of the introduced proposal, Article 1, which contains the abrogation of the raising the retirement age. And the explanation is that the Social Affairs Commission is presided by a member of the presidential majority. And in this commission, the presidential majority has the majority. So by a vote of show of hands, the commission has rejected Article 1. Of course, the opposition has quickly introduced amendments in order to restore this Article 1 that was repealed by the Commission. And so now the question is, if the President of the National Assembly, Yael Braun-Piquet, who is a deputy, a member of the presidential majority, the question is, will she allow the amendment to be discussed and voted in the plenary session on June 8th? And the reason why she might not allow it is because of yet another article of the Constitution, which is Article 40. Article 40 of the Constitution prohibits any parliamentary initiative that had the consequence of aggravating the state expenses or the state charges, financial charges. So basically, whenever a parliamentary initiative, whether it is a new legislation or an amendment, has a financial consequence, the president of the chamber, the Senate, or in this case, the National Assembly, has the possibility of blocking it effectively, except if the government explicitly allows it. And so, of course, it is much more difficult for the opposition to bypass Article 40 than for parliamentary groups of the majority. And so on this basis, on the basis of Article 40, the presidents of the two chambers can effectively block all initiatives coming from Parliament, except when the government accepts the new budgetary charge. And then again, such a choice from the president of the National Assembly to reject the amendments of the opposition based on Article 40, such a choice would be perfectly constitutional. It still poses a problem of legitimacy because it would prevent a vote, the only vote, in fact, on the extension of the retirement age. So again, what was the problem initially with Article 49, paragraph 3, which is Parliament didn't get to vote on this particular measure, that problem is reproposed yet again with this other last, maybe possibly desperate attempt of the opposition to actually put this particular measure, the raise of the retirement age, in front of the National Assembly in the plenary session and have a vote on this question. So we can see here why all those constitutional mechanisms that are related to the rationalization of parliamentarism, that is the main character of the French Fifth Republic, all those mechanisms are increasingly seen as constraints on the democratic process of the legislative procedure in parliament. And if this was not enough of a challenge already for French democracy, I think that the main problem is that this challenge is reunited with another one, the absence of a strong constitutional review of the interpretation of the Constitution. And so all the limits of the French Constitutional Council that I would like now to focus on. How am I doing on time? Do I have a little bit more time to talk about?
I would say 7 minutes, 8 minutes. So
Perfect.
Go ahead.
And then we can continue in the discussion. So I said that there isn't a strong constitutional court in French, which is true. But I argue in another article in French that I will put in the comments later if you like. I argue with two other colleagues that the Constitutional Council is in fact much more of an activist court than we're used to describing it in France. And I will explain why in a few minutes. The Constitutional Council had one main question to decide, which was if the combination of all the constitutional mechanisms that allowed the majority to force the adoption of this reform, so if this combination is in fact constitutional. And so the assessment was in the hands of the Constitutional Council, as France has no constitutional court per se. The closest France has to a constitutional court is the Council. And the Council is known as being generally differential towards the executive power, also because it is composed not by judges, but by former politicians generally, appointed by the three highest functions of the Republic. So the President of the Senate, and the President of the National Assembly. And in particular, on this case, the Constitutional Council had to decide on two separate issues that are very different but related. One was the procedure used by government and parliament to adopt the reform. And the other issue was the possibility for the opposition to use a participative democracy tool, which is a form of referendum. It's called the referendum of mixed initiative, mixed because the initiative is both parliamentary at first and then popular secondly, as the electorate has to support the parliamentary initiative for the referendum to take place. In both decisions, the Constitutional Council rejected any attempt to challenge the reform and to limit the raise of the retirement age. The two decisions of the Council, so there are decisions and not judgments, because as I said, the Council is not composed by judges. And the two decisions were announced on the same day, April 14th, 2023. That is also why it is interesting to analyze them together. Two decisions on two different aspects. And what I argue is that those decisions show an activism from the council and not a form of self-restraint. And this is even though self-restraint continues to play a very central role in the way the council constructs its legitimacy. What the council decided was, for the first question on the legislative procedure, the council confined itself to a minimal review. That is to say that the council found nothing to object to all the different mechanisms that were used by the government and parliament in this reform. So no constitutional objection for the inclusion of the reform in a social security budget rectification, which, as I said, is unusual. No constitutional problems in the use of Article 47.1. So that also was upheld by the council. And this, even though it's a bit technical, I think it's interesting. The question was related to the application in time of the reform. So in order to have a finance, a law on the budget of Social Security, this law has to apply to the current year, which is typical of financial laws. Of course, the retirement reform, in a way, did apply to the current year because it is meant to be in effect starting September 1, 2023. But of course, the effects of the reform extend far beyond 2023. But that is not a problem for the Constitutional Council. That question is not mentioned at all by the decision, and the Council limits its control by saying, and I quote paragraph 11 of the decision, that the government's original decision to include them in a rectifying finance bill does not in itself infringe any constitutional requirement. So on the procedure, and the same goes for Article 49, paragraph 3. For the Council, the government, and the Prime Minister in particular, acted in conformity with the Constitution, following the letter of Article 49, paragraph 3. And so it is absolutely possible for the Prime Minister to engage the responsibility of the government on this bill, and this is what the Prime Minister did. So there is no evaluation from a constitutional point of view by the Council on the combination of all those mechanisms. They're discussed separately, one after the other, and no constitutional fault is found in any of them. The second decision on the same day is the one regarding the possibility of launching a referendum. This referendum was meant to be on a legislative initiative that contained only one article, a single article, prohibiting the government to raise the retirement age from 60 or above 62 years old. So this was an initiative coming from 1/5 of the members of parliament. This is the procedure. They must initiate the referendum procedure, and then 1/10 of the electorate has to support the initiative. But before submitting the initiative to the electorate, in order to gather the support signatures, the Constitutional Council has to verify if the initiative is constitutional or not. And on April 14th, the Constitutional Council decided that it was not the case, that the initiative was not constitutional, it was not in conformity with Article 11 of the Constitution because, and this is particularly interesting, the proposed reform was not important enough to be the object of a referendum. What does it mean? So the Council has developed this idea in the past few years, that a reform of insufficient importance cannot be the object of a mixed initiative referendum. So this idea was expressed quite generally, laconically, in its previous decision on a referendum in 2022. And then now, in April 2023, this requirement of importance of the proposed law reappears. And this is why I'm arguing that the Council was an activist court in this case, because it took the liberty of controlling the content of the reform and measuring an element, its importance, that is, to say the least, quite difficult to measure. And by doing that, the Council has heightened the use of the shared initiative referendum to the point where some are wondering whether this procedure still has a future, because it has never been used, and it is yet to be tested. And I don't think there's much of a possibility in the future if the interpretation of the Council remains the same. Anyway, those two decisions of the Council show two things, in my opinion. One is that there is the lack of a strong constitutional court in France that is legitimate enough to actually verify in depth the constitutional procedure and all those mechanisms that are constitutional in a sense if taken separately, but might be an abuse of the procedure and might be unconstitutional if combined all together. And at the same time, when discussing the options of the parliamentary opposition, the Council has been much more activist than it is usually supposed to be, or at least that we discuss it to be in French doctrine, French legal academia. So I might stop here just by concluding with this main problem that I mentioned since the beginning, and it is contained in the title of this contribution, which is the potential contradiction between what's constitutional and everything in this last 2-3 months was constitutional to the letter, in a sense, and what's democratic, and what's supposed to follow the democratic promise. And I think two arguments that are mentioned by both the President, Emmanuel Macron, and the Prime Minister, Elisabeth Borne, show those problems, because both the President and the Prime Minister had said that there was a vote on the reform, which is actually inaccurate until now. And if the vote on June 8th does not take place, the only vote that actually took place is a vote on the confidence of the National Assembly in the government, and not a vote on the substance of the reform. Those are not the same vote. And the other misrepresented, I think, situation or event is that the majority has said over and over that the decisions of the Constitutional Council conclude the democratic process, while there is, of course, as we all know, a fundamental difficulty in making a constitutional court part of the democratic process. That is not self-evident. We can argue that it is or that it isn't, but it is presented as if these decisions by the Council conclude the democratic discussion, which poses the question of the legitimacy of the Council and the legitimacy of constitutional review in general. So I think I will stop here, and of course we can go back on many of those points, especially maybe the most difficult and tactical ones during the discussion. Thank you very much for listening to all of this.
Thanks indeed, Eleonora. It has been a very rich presentation. In fact, this is pretty much of an unfinished business because, as you have just mentioned, there has been this initiative from the Lyotte parliamentary group to abrogate the reform. It will most likely end in a failure. I have a couple of questions and remarks, but if any of you wishes to go first, Umberto Lattanzi.
First of all, thank you very much for the brilliant presentation. It was very insightful for me. So my question would be like, based upon a comparison with the Italian experience, where we witnessed an abuse of governmental decrees for years right now, which are coupled with a question of confidence, maxi amendments. So really, very strong constraints on parliamentary procedure. So my question would be, what is the role that you give in providing democratic legitimacy to the fact that Parliament actually votes, even if under very strong constraints on a proposal? Because from what you explained beforehand and from what I understand of Italian procedure, the main difference is that in this case, in the French case, there was a lack of a negative vote, whereas in Italy, there is still a positive vote on a proposal. So do you think that this is a significant difference between the two systems in providing democratic legitimacy, or is the Italian system just as flawed? I think it is significantly flawed. I don't know if it's as seriously as the French one from a democratic perspective. So thank you very much, and thanks again for your explanation beforehand.
Oh.
Thank you so much. Should I answer right away?
We are going to collect a couple of questions, I think, if there are any of them. Giuseppe?
Thanks indeed for your brilliant presentation, Eleonora. I learned a lot, and many things are now very clear. I mean, thanks so much. I have a question concerning more your post for the Verfassungsblatt, because you correctly started from this distinction that I like very much, that between constitutionalism and democracy. But then you put a link, to the article by Mark Tashnet and his article Authoritarian Constitutionalism. Now, I don't understand, if I'm not sure that that article, that delivers the message you wanna perhaps, give us, because actually in that article, it was referring to systems in which you have free elections, but you also have forms of limitation of the freedom of speech. I don't know if the kind of idea he has in mind, can be used to describe the different system. But since I'm not sure about that, I would like to ask you to clarify this. Because I think it's a very important passage, because otherwise one could think that perhaps we are experiencing a kind of abuse of the constitutional system similar to those present in authoritarian or in populist systems, while I don't think this is your point. And that's why I would like to ask for a clarification. Thanks so much.
Thank you, Giuseppe. Nicola Abate, and then I think we may stop this first round. Nicola.
Yes, thanks for your presentation. It was amazing. I have a question about the reaction of constitutional lawyer in the face, in the light of the judgment of the Constitutional Council. That is, usually the French system is described one as parliamentary sovereignty, and then the role or the place of Constitutional Court is very weak. And is there some change in the view on constitutional council by constitutional legal scholar? And I think it's because I read some tweets on Twitter about this argument, about this, how many legal scholars wanted to that the Constitutional Council acted as a sort of equilibrium, acted as to take an equilibrium between legislative power and executive power. Then I want to know how this debate go on in French.
Thank you, Nicola. Now it's up to Eleonora.
Thank you so much for all those questions. It really allowed me to reflect a little bit more. Starting with the comparison with Italy, I don't think France has an exceptional situation. I think that we can see similarities in many other systems. I think that there is, and there has been, we could discuss about COVID and how that affected the disequilibrium between executives and legislative powers. So I'm focusing on France, but I don't think that France is the worst case scenario, that all those other, all the other examples in Europe are perfect, far from it, and especially the Italian case. But I think that what Umberto, you were saying about the difference with Italy is true. I think that one of the main problems of all this procedure is that at no point, and this is why this is the focus, the real focus of the conversation of these days, last week and this week, is that the majority is afraid to put the retirement reform in front of the National Assembly. And that's a problem. Whether it is true or not, the narrative, I think, is problematic for democratic legitimacy of the entire constitutional system in France. The narrative that you have a majority, a relative majority, in government and at the presidency. And of course, I didn't mention this because I think it is well known, but of course the role of the president in France has nothing to do with the role of the president in Italy, right? The president is, in fact, at the origin of this reform, as well as all the political decisions. And so the narrative that you have a majority afraid to confront parliament is a problem. And I think that this narrative is nourished by the absence of a positive vote, as you framed it, which I think it's a very good way of seeing it. There's only been a negative, the lack of a censure of a negative vote, but there has never been a positive vote on the particular measure that is the raise in retirement age. And I think that this difference is significant between the Italian case and the French case. And I think that this is why the situation is so problematic. If we want to do some fictional politics, we could think about what would have happened. Let's imagine that the government didn't use Article 49.3. They went through with the vote. They possibly had the numbers. It was just risky, but it was possible that the reform would have passed in the National Assembly. Then I don't think we would be in this predicament today. I don't think that it would be such a problem to have a new attempt, a new legislation abrogating the adopted reform. I don't think it would be so problematic if the president of the National Assembly said, okay, it's clearly, it falls into the scope of Article 40. It's clearly a budgetary aggravation, because it is, right? That is pretty much self-evident. But all parliamentary initiatives are, but that's another problem. But I don't think that this decision, the upcoming decision of the president of the National Assembly would be so problematic had there been at least one positive vote in the National Assembly about the reform. And so that, I think, also strategically was a mistake. Not only it is problematic in terms of democratic process, but I don't think was very enlightened or smart, let's say, because of all the consequences that we're seeing now. I don't know if it answers the question. For your question, Giuseppe, it's a very important question and one that I've been discussing with other people online and by email. I definitely do not assimilate the French situation to those illiberal democracies or constitutional autocracies that, for example, Mark Tashnet, along with many other colleagues, envisions. What I think there's two possible answers to your question, and they're both valid for my piece. One is I wanted it to be provoking at a time where the discussion was about how was it possible to contain this whole situation quickly enough by saying it's constitutional, therefore it's democratic, nothing to see, please circulate. And I wanted to put a spotlight on that because I think that was a real democratic problem, to just do this equation, whatever is compatible with the Constitution, because of course, no one said it that way politically, but the idea is an idea of constitutional law students of first year in law school, right? The Constitution has been adopted by the people in 1958. Therefore, everything that is in the Constitution is democratic. Therefore, if we follow the Constitution to the letter, democracy is saved and there's nothing to see. And I wanted to put a spot which is not discussed often enough in France, I think, of all those cases, including the one Mark Tashnet mentions, where, well, you can follow the Constitution to the letter, and that's not a reason to think that democracy is saved and everything is good and there's nothing to see, right? So I specifically wanted to make that point in order to also to show that I don't think in France this discussion is present enough of basically what you can do with the Constitution to make it undemocratic. Still, I don't think that we are in a similar situation of, you know, free election on one side and limitation of constitutional rights on the other side, even though if you discuss it with my colleagues in administrative law that are studying and have been studying all the prohibition of protests that have been followed, the debate, they might see it otherwise, but this is not something that I studied in the article myself. The other question, or maybe the other part of the answer, which is not merely provocative, but it's really something that I would like to think about more, and possibly a blog post is not the best place, so I'm thinking of expanding it in an actual article. But this distinction between constitutionalism and democracy, I think, can be discussed outside illiberal democracies, and this is maybe something that's a bit more new, that hasn't been done a lot. So we in constitutional scholarship, we have focused on Poland and Hungary and Turkey, and how all these cases use constitutionalism to undermine democracy, or use democracy to undermine constitutionalism. You can see it both ways. But maybe we haven't focused enough on all the possibilities to do the same in, let's say, less flawed constitutional democracy, which France is. And so maybe that's a new field that this case has opened for us. I don't know if it answers to your question, but it's really, really interesting, and I have to think about this a little bit more. About constitutional lawyers and constitutional doctrine in France and the role of the Constitutional Council, that is a very interesting question, because one might say that at the same time, nothing has changed in the perception of the Council by constitutional law scholars, and everything has changed at the same time. what do I mean by that? So the general view of the council is a weak court and there's nothing to be expected from it is still there. That was the big part of the constitutional discussion by academics in France, right? There's nothing to be expected. Of course, no one predicted a different outcome from the one that we had. No one dared to imagine a situation where the council actually would stop such a combination of constitutional mechanisms by the government. No one expected that the referendum, I mean, maybe for the referendum, there was a bit of more of a suspense, but not much. So nothing was to be expected. It is a weak court. It is not legitimate. And that sort of discourse stayed the same. At the same time, we experienced something different this time for two reasons. One is that for the first time that I can recall in recent years, the people actually expected a lot from the council. The protesters, the unions, the parliamentary opposition, and people in the streets were invoking, you could see like, slogans in the protests, waiting for the council to do something. That is new. And as a consequence on legal academia, that has prompted a normative input from academics to ask the council to do something. So you see why I say, there's nothing new and everything is new, because from the descriptive point of view, everyone said, this is what's going to happen. We don't expect anything more. But from the normative point of view, many scholars, and probably the one that you saw on social media and you referred to, tried to influence the council, sort of putting on the council much more pressure than they usually do. And so I think those two positions coexisted, and they do coexist in French legal academia. But at the same time, the position of academics saying that the council is a weak court hasn't changed. What I try to say, and I wanted just to go back on this, because this was, not alone, we were three colleagues saying this, is try to change this narrative, not necessarily of a weak court. We know it is a weak court for various reasons in terms of legitimacy, but we wanted to change the narrative of a self-restrained court. Because actually, what we're trying to say is that by not deciding, by not interfering with the government's choices in terms of legislative process, the council did choose actively to not restore the equilibrium between the powers. And furthermore, the council decided actively to aggravate the unbalance that the Constitution actually enacts. And so that is not self-restraint for me. This is not what self-restraint is about, or at least in a certain interpretation of it. I don't think that the council showed a lot of self-restraint, but much more of an activist take on what the council decides to do and not to do on this problem of the equilibrium of powers.
Well, thank you, Eleonora. Are there any? Camilla Galitz.
So, good afternoon. Thank you for your presentation. It was very interesting and also very complex, but crystal clear and easy to follow despite all the composite mechanisms. So I have a couple of questions. The first one regards maybe the social reaction. So as you said, it was followed by huge protests and anything else. So if there is such a negative reaction, I think it was not positive protest. So on behalf to support the reform. So then why did these protests fail? So why couldn't they be successful? Regarding the position of this Constitutional Council, whether it is weak, whether it is self-restraining, whether it is activist, why is the system okay with that? Why don't they want to change the position of the council? Maybe it might be a genuine question or a naive one, but from my point of view, or of other constitutional systems with a strong constitutional court, I just fail to understand why the French one is okay with such a weak body of control. And the last question regards the contextualization of this reform. So in the context of this, let's say, instrumentalization of the constitution. So was this the only one exception? Maybe, I don't know, in the French system. So regarding the French system, not the overall situation in Europe, but are there now any other critical points in the French system, other reforms or other already adopted maybe laws that also point to this, let's say, a contrast, or contrast between being constitutional but not being legitimate. Thank you.
Thank you, Camilla. There is a question by from Alessandro Moroso.
Yes, thank you. Thank you very much for this brilliant presentation, and also for the detailed picture of the procedure and the legislative process. But I have a curiosity linked to your introduction, because you said at the beginning that there is or you see a connection between the weak Constitutional Council and the parlementarisme rationalisé. And I would ask you maybe to elaborate a bit more on that, because in my understanding, the traditional reason for the weak Constitutional Council in France is the deference towards Parliament, towards the legislative, because it is the expression of the volonté générale. But actually here we are saying the opposite, because if you link the weak Constitutional Council to a parlementarisme rationalisé, it is no longer a deference towards the legislative, but it's a deference towards the executive. And then there is no check and balance anymore. Simply, it's simplicity. And then, I was puzzled a bit when you said it is an activist court, but I understood in which sense, thanks to your last intervention, you see an activism in the sense of taking political positions. But then if this is your understanding of activism, then I would push Camilla's question a bit farther and say not just why or whether French people are okay with that, but whether or not you see a risk of the political system to crumble because of that, because of a total lack of legitimacy or a total lack of check and balances. Thank you.
Thank you, Alessandro. I have a question. There would be many more questions, but I think this is the most important. You have made reference to a number of constitutional tools, limits on resort to Article 49, paragraph 3. The mixed initiative referendums, the possibility for opposition groups to have a say in the activities of the parliament, all of these were part of the 2008 reform. So my question is, have the Conseil Constitutionnel, the President of the National Assembly, and so on and so forth, sort of sterilized, tamed, contributed to taming the innovative potential of these constitutional tools that were part of this attempt to modernize the Fifth Republic, and right now, overall, seems they seem to be of limited usefulness, limited use. Other comments? Otherwise, Eleonora.
Thank you so much for this other round of questions that are particularly important. And starting with Camilla's questions, so the social reaction was definitely all negative. There hasn't been, let's say, manifestations of positive or of approval, let's say, of the reform. Why did they fail? Well, I'm not sure that I actually know all the elements. There are a lot that are related to the role of unions in political science, and I'm not an expert of French unions, but from what I know, the lack of unity in the end of the different unions has played a role. There was a common front of all the unions at the beginning of the protest, and then slowly the different unions had different conversation with the government, and then they had different reactions, and so the call for unity ended at some point. That's one reason. The other reason is, I think, very much related to this combination of all the tools used in approving the reform. That is, the shorter the debate, the more constrained the debate is. Imagine also, not only there is this question of the 50 days maximum for the approval of this reform, but there's also the very short delays that the Constitutional Council has to decide. That is very unusual in comparative law. The Constitutional Council has 1 month to decide ex ante on legislation that is submitted to its attention. So it is very short. It could be even less, because if government asks, the Constitutional Council only has 8 days in an emergency procedure that was not used this time. It was the only emergency thing that the government did not decide to use. But still, 1 month is very short. And so I think that by limiting all this procedure in time that much, well, then the protests at some point do not have much to work with, right? Because the reform is approved, and at some point the social movement sort of slows down when the impression is that there is not much to be done anymore, right? Because the procedure is done, the council has said it's constitutional. The same night, the president signs the bill, and for part, at least part of the protester, that's over and done with. And I think that also explains the end of the protest. The other question is interesting, very interesting also. Why is the system okay with that? With the council being weak in terms of constitutional review? I think one part of the explanation is historic. Historically, France does not have a good relationship with constitutional review, especially with strong courts, right? And so I don't think that has changed. I think the spectrum of the government of judges, le gouvernement des juges, is still very much present in France. And so I think overall, the system is very much okay with having a weak form of constitutional review. Will this last? I don't know. Maybe not. Maybe slowly with the interactions with other European countries, with European law in general. Maybe this can slowly change, but for now, I think that there is no indication of a strong will for a stronger court or a stronger form of constitutional review. Has this instrumentalization of the Constitution appeared for the first time? No. There is a history of using those different tools of the rationalized parliamentarism. What's new is the lack of an absolute majority. And so I think this is what makes this particular case somewhat new and particularly interesting, is that usually all those problems didn't occur. Why? Because the president had an absolute majority in the National Assembly, and so there was no need for all those tools together. And at the same time, there was a strong claim of legitimacy, of democratic legitimacy by the presidential majority, by saying, well, we have a very comfortable majority that is the result of a democratic vote. What's the problem? Now there is a problem. There is a problem because the parliamentary majority is only relative. And so as a result, the presidential and governmental majority have to use those mechanisms much more. And at the same time, they don't have this strong democratic claim by saying, we had the majority, you voted that way, and we're going to go along with the political program of the election. So I think that is what's sort of new. Will it happen with other reforms? I think right now on the political agenda, that one was the most controversial. I think for at least what I know of the foreseeable future of the next reforms, I think the coalition will hold much better, and so the problem will not arise that much. But of course, we'll have to see what happens, because the term is still long. We're only on the second year of a 5 years term for Emmanuel Macron. So necessarily he will want to do something more, but I don't foresee as of now such a controversial reform. So Alessandro's question about the link between parlementarisme rationalisé and a weak constitutional council is interesting because, first of all, of the origin of the council, right? As you probably know, the Constitutional Council was part of one of the tools of rationalized parliamentarism, because at the beginning, the council was meant to contain parliament in its role and protect the executive as a result. Of course, since then, the council has evolved. It is less weak than before, in a sense, especially because of its role on fundamental liberties and fundamental rights. And so the council has emancipated itself, let's say, from this initial role that the Constitution gave to the council. But it is true, I agree with your assessment, that of course, if the deference, that is the problem, and that is why I posted in the comments the second article that I wrote in French with Stéphanie Annette-Baucher and Marc Bourgoisis. And what we argue is that a deference to the legislator, that is a typical argument by the council, actually means a deference to the executive. Why? Because the executive is the legislator in France today. Legislation is 90-something% originated by government bills. And the government has such a place in the legislative procedure that the real question is, who's the legislator in France? Right? And this is a typical question that we ask first-year students. My students, when I do constitutional law, one of the typical task or question that we ask for the exam is, qui fait la loi sur la 5e République? Who is the legislator in the French Republic? And the expected answer is, at least for the most part, if not exclusively, the executive power, the president and government, right? So while the argument of the council hasn't changed, and the argument is, I am deferent to the legislator, the real question is to whom this deference profits. And it is much more the executive than the legislative power. That is what Parliament is starting to understand, right? This is why you hear more and more declaration from all the members of the opposition saying we don't, and also some members of the majority actually saying we're useless. We don't have any room of maneuver. We're not the actual legislator. And this is quite recent. And so I agree that the result is a lack of counterpower. And that makes me, that makes a good link with Giacomo's question about the reform of 2008. What the reform of 2008 was meant to do, as you said, is modernize the institution in the sense that Parliament would have to have a bit more power as opposed to a very strong executive power, too strong maybe. And I think that what happened since March has limited the scope of the reform. Not only of the reform, there's, for example, another episode that I didn't mention before that might go in the same direction as what you were thinking. That is, it is not in the 2008 reform, and it's not in the Constitution, but it's a custom, a customary rule that the Finance Commission in the National Assembly is presided by a member of the opposition, right? This is a custom. It has been the case for the last decades. And of course, the idea is to create a sort of balance by giving such an important role, because the Finance Commission is particularly important, giving it to a deputy of the opposition. And so, as a result of this customary rule, the Liot proposal that is under discussion right now passed the scrutiny of the Finance Commission, because of course, the president of the commission is against the reform, right? And so what this customary rule can be added to all the written rules that were meant to give more power to Parliament. And what's happening right now, the possibility that the president of the National Assembly would actually undermine the Finance Commission by saying, no, you should have rejected this because it's contrary to Article 40, because it's an aggravation of public charges. And so because the Finance Commission didn't do it, I have to do it as president of the National Assembly. That, I think, goes into the direction of what you were saying, that it is a way of limiting the results and the expected results of the re-equilibration of powers, which was the original objective of the constitutional reform of 2008.
Well, thanks indeed. Now, I think we are almost finished with our time, but if any of you still wishes to raise some additional points.
Oh, sorry, I think I forgot to answer one point. It's just coming to me about my definition of activism. I forgot that, right?
Sure. Yes.
Well, I think so. I posted the article. I think what we wanted to do with these two colleagues with which I wrote it was to try and put out there a new interpretation of what the council is doing. What we wanted to do is to deconstruct this general position, which is usually an agreement between the council itself and legal academia in France, which is the council is not a court, therefore it has a problem of legitimacy, therefore it is more legitimate the less it does, right? By limiting itself to a stricter role, that is where the council draws its legitimacy, right? So you have those two counterpoints, the council itself and legal academia, that go into the same direction, which is to say the problem of the legitimacy of the council is somehow resolved by not being very activist, or comes from its self-restraint, if you wish. And we wanted to deconstruct this relation because I think it's a bit too easy for the council itself to justify this. So there's a sort of I'm actually formalizing it as we speak, because we didn't think about it this way. But now that I think of it, we saw it as a bit too straightforward as a discourse to say, well, we criticize the council because it is too weak, because it doesn't have legitimacy. And the more we do that, the more the council will use deference as a way of reinforcing its legitimacy. By saying, I'm not deciding anything. I'm just, minimally controlling that the constitution is respected, but without interfering. And what we wanted to say is that this is a way of interfering very much. And of course, it starts also from a realist point of view, at least in a very general sense of the word, by saying, well, there is no straightforward interpretation of the constitution. And so by interpreting in one way or another, the council is deciding, really. And it is deciding in a very, maybe not necessarily activist in the traditional Anglo-American sense of the word, but at least in a very active way. It is not a passive organ in the French separation of powers. It is a very active court, indeed. I hope I remember everything. I took notes, but I'm a bit tired, so I think I might have forgotten a few points. If I have, just don't hesitate to tell me.
This is of your success, I would say. I mean, getting so many questions, it is indeed an evidence of how interesting your seminar was. Thanks indeed.
Thank you so much.
No, thank you, Eleonora. It has been a great presentation and a very rich and fascinating debate.
Thank you all for the questions. That really made it so much more interesting.
I think there will be another chapter sooner or later.
Yes, I think there's going to be another chapter of my article as well. So I will share it with you, of course, when I finish it.
So thank you again, and see you in the next few days for other seminars and webinars within the framework of STAS. And please join me in saying thank you, a huge thank you to Eleonora Bottini for her presentation today.
Thank you for the invitation. Thank you very much for the invitation and question. Have a great day.
Bye.
Bye.
Grazie.